This employment law video is on restrictive covenants. Types of restrictions. A restriction could preclude an employee for a certain period of time after leaving employment for working for a competitor or setting up in competition. Other restrictions could preclude an employee for a certain period of time from soliciting or poaching staff or clients of the employer, or dealing with the clients of the employer, which would include even if clients approach the employee. The law. The general rule is that a restrictive covenant is only enforceable if it goes no further than necessary to protect the legitimate interests of the business. Factors that might be relevant could include the type of business involved, the seniority of the individual concerned, their access to clients and confidential information, the length of the restriction, and the geographical area covered. The important thing to remember is that an employer cannot rely on a restriction if a less onerous one would have adequately protected the business. Let's take, for example, a restriction precluding an employee for 6 months from soliciting or poaching clients of the employer that they were involved in the last year of their employment. It may sufficiently protect a company selling widgets if within that 6-month period a salesperson could be appointed and secure relationships with those clients. In those circumstances, an additional restriction prohibiting an employee from going to work for a competitor would most likely be unenforceable because it would go beyond what is required. There may, though, be some situations where a non-compete restriction could be justified, where, for example, it's difficult to police a non-solicitation restriction, or where the individual is senior and has particular access to confidential information. Networking sites. Messaging or posting to connections who are clients of the employer could potentially amount to a breach of a non-solicitation restriction. Even updating a profile could potentially amount to a breach. Tips. It's important to check for restrictions in your employment contract before signing. That's the time to raise any issues and, if necessary, negotiate with your potential employer. Sometimes, for example, you may be able to change those particular restrictions. For example, if you're introducing clients to your employer, you may be able to ensure that any non-solicitation restriction after you leave excludes those particular businesses, so that you would then be free to take those businesses with you when you leave. That's my video on restrictive covenants. The usual caveat is that this video is for guidance only and should not be relied upon for specific advice. For more information, do visit my website, and if you'd like to receive notifications on other employment law videos, do subscribe to my channel.